Thank you very much for this introduction. It's for me a pleasure to be here. And my presentation mainly focuses on regulating artificial intelligence. There is a huge interest from different actors to regulate artificial intelligence. And in regulating artificial intelligence, we have the pointer. Thanks. In regulating artificial intelligence, we have two different core values that came relevant: law and ethics. Okay. In what sense? I try to address this topic through three different questions in order to try to understand the existing relationship between law and ethics. So the first question is, why ethics? And the short answer is uncertainty. If you consider the debate about large-scale data regulation, artificial intelligence, you can find that after a long period in which we focus on regulating using law, in the last few years, we shift the focus towards ethics. So why? On the one hand, this is not completely new, because ethics and technology are two different elements strictly entangled. We have a long tradition of discussion, reflection on the ethical issues related to the new technologies. And if you look also to the past experience, the period in which we have this kind of focus on the ethical impact of technology are when we have new technologies, and technology that impact and change the society and the manner in which we have a relationship with other people or with the structure, with the system. And so, at the end, the ethical issues are strictly related to the situation in which the framework is changing, in which there is an uncertain level of uncertainty in the situation. So, why now? Why with regard to artificial intelligence? Because artificial intelligence and the related process of datification has changed part of our life, increasing the manner in which data are collected, used, and exploited, create a new manner to extract value from data. Predictive analytics and other systems are able to predict what happened in society, what happened with regard to a single person, and also to drive society, to support the decision maker in taking their decision, and in some cases also to replace the decision maker in taking decision. So these are new issues related to the impact of data processing in society. And at the same time, this issue should deal with paradigms that are created in the past. For instance, data protection paradigm is something that came from the past, from the 70s, and the systems that are used now are completely different compared with the system that we had at that time. And so for this reason, there is concern among citizens, there is concern among regulators, and there is not a quick answer in the existing framework. And for this reason, we try to reflect on the ethical issues. Ethics is something broader than law, and is something that represents a manner to try to address new challenges. And so we come to the second question. Why not law? Why ethics and why not law? And the short answer is it takes less time to write a paper on ethics than a regulation. If you consider, for instance, the experience of GDPR or other regulation, we invest a lot of time to make a regulation. There is a long process, a democratic process, that engage a lot of different entities. And ethics guidelines, ethics code are something different, are similar to soft law, is something that you can make in an easier manner and in a quite short time. But at the same time, law can provide also a framework. And if you consider what happened to data protection, and my focus is on data protection because, of course, the largest part of this system focuses on the use of data, and many of these data are personal data. And if you consider the changes in the legal framework, you have to remember that we have a new regulation, GDPR. We have a modernized version on the Convention 108, that was the original European model for data protection. We have the revised version of OECD guidelines on data protection. So legislators try to address the new challenges. Legislators are not indifferent. So in this sense, ethics is not the only solution in this context of uncertainty, but also the legal framework tries to provide some answer. But what is the limitation? The limitation is related to the fact that this legal framework are based on previous model, necessary based. The GDPR is based on a directive that was adopted in 1995. And this directive was based on the Convention 108 that was adopted in the early 80s. So what is the consequence? The consequence is that the fundamental pillars, the categories, the theoretical categories that we have in this regulation are the categories that were created at that time. In a time in which data processing was very simple. In many cases, was vertical in terms of system, with a few different entities involved, without any ability to predict the future or try to predict the future, with a limited impact on society because the collection of personal data was quite limited at that time. And so, if you consider some notions like personal data and non-personal data, if you consider personal data and anonymous data, if you consider some figures that are relevant in this scheme, like controller and processor, all these notions are not so adequate to address the existing system. Consider, for example, the purpose limitation principle. When you collect the data, you have to know and communicate to the data subject the purpose of your collection. But how you can do that when you use artificial intelligence in a system in which, in many cases, you don't know what is the final goal? So the purpose is absolutely vague. So the scenario is changed, and is not only a scenario related to data protection, because the extensive use of data and data collection, of course, touch different kind of issues in society. And so we have data protection, but we have also competition. We have the use of data to sort out people, to select people, and so we have issues related to discrimination. We use data to provide services, and to provide services in a different manner to different people, or to surveil people in some case. And so there is several human rights that are potentially impacted. So it's a more complicated system. And there are ongoing initiatives that try to address, from a legal perspective, this situation. But of course, the legal framework is not enough. And so the third and last question: will ethics cannibalize law? The answer: we need both. This is, from my perspective, is an important point. We have now, due to this hype on ethics, a lot of documents that deal with ethics, that consider the ethical issues related to artificial intelligence, related to the use of data. The problem of some of these documents is that there is a sort of confusion, a sort of overlapping between the ethical framework and the legal framework. As a consequence, some requirements that are mandatory, that are in the legal framework, are presented as ethical requirements. For instance, some requirements related to data quality, data minimization, consent, and so on, are reshaped and are described as ethical requirement. Of course, in a democratic countries, ethical values represent the ground, the basis for legal requirement. But when an ethical value is transformed in a law provision, the law necessarily shape this value in a more specific manner, providing a more specific framework. And so in this sense, it can be misleading, giving, for instance, to the companies the message that some values are mere ethical values and are not only legal requirement. And unfortunately, in some documents, there is this sort of confusion. Another important point, I think, is related to the ethical framework that we want to consider. Because in this document, there is a lot of ethics, but there is a very few words about which kind of ethics we want to consider. Because as you know, ethics is part of philosophy, so there are different kinds of branch and approaches in ethics. There is the consequentialistic ethics, the utilitarian ethics, the virtue ethics. So which kind of ethics inspire your ethical values to govern artificial intelligence? And it's not only a problem of theory, it's also a problem of geographical origin. For instance, all these ethical documents are mainly based on the ethical value in the Western country. And the Asian and African ethical values are not well represented in this system. And this is also another issue if you want to create some global charter of ethics principle for artificial intelligence. Another point, I think, is that this different kind of layer that exists in the realm of ethics can provide flexibility, but this flexibility can be also misused. For instance, company can prefer to create ethical bodies, to adopt ethical charter, rather than focus on regulation and compliance with law. So there is an increasing interest to be ethics, but it's not clear what is ethics in many cases. The ethics of the company, the ethics of the local area of the company, the ethics of the advisory board of the company. So the risk is the so-called ethic washing. So you use ethics as something that is useful for your market, for marketing purpose, but not to really shape the process inside the company. I don't want to say that this is the manner in which act all the companies, but of course, this is the risk that we have to consider. Also because this different element concerning the ethical framework create another situation of uncertainty. Because if there are different ethical sources, if there are different ethical models, if different entities create their own ethical charters, of course, at the end, we have a confused picture. And so if ethics, recalling the first slide, was an answer to uncertainty, probably this answer does not fit so well. So what we can do, I think that it's very important to focus on these two elements, law and ethics. And keep in mind that they are different. They are different in purpose, they are different in methodology, and they are different in impact. It's very important to have some kind of regulation based on law in the field of artificial intelligence, and as far as possible, based on the principle that can be considered as common at global level. In this sense, I think that the focus on human rights and fundamental principles is very important. Fundamental freedoms is very important. Why is very important? Because these values are commonly accepted in many countries, then of course human rights are partially shaped in some geographical area and in other geographical areas, so there are some differences, but all the countries recognize this kind of framework. And so this framework can provide a good backbone to build on the regulation. Because we need a backbone. We need something that is common, that is generally accepted. And then ethics. Ethics should have a complementary role. Ethics should not replace the regulation. Ethics should add something. In what sense? You can create, for instance, a smart cities plan that is consistent with data protection because you have all the legal requirements. But it doesn't mean that the citizen want this kind of city, want this kind of invasive technology, want that part of the decision are adopted by machine and so on. This is not a legal problem. This is an ethical problem. And not only an ethical problem, it's a social problem in many cases. In this sense, social issues, ethical issues are very important because the legal issues are only part of the society system. They regulate only some aspects, but there are other aspects that we can also call political decision if you want, that should be inspired by ethical value and social value. So in this sense, ethics should not overlap the legal framework, but should extend the viewpoint, considering the impact of the decisions that we adopt in terms of ethical and social consequences. This is very important. For this reason, I talk about law and ethics without confusion between the two items. So, in this sense, we can regulate artificial intelligence, taking into account all these elements. And the outcome should be not necessarily an hard law regulation, or not necessarily only ethical guidelines, but a sort of mix. We have several different schemes that we can adopt. We can have some basic rules grounded in human rights. We can add some soft law through the system of the so-called co-regulation, in which the hard law provide principle, and then companies, stakeholders, use that principle to specify them in a specific sector, in a specific context. Also because I think that regulating artificial intelligence is quite difficult, because artificial intelligence is a technology, can be applied in business, in healthcare, in warfare, and all these sectors have different kind of values from the legal and from the ethical perspective. So in this sense, it's very important to have some general principles and then some specific application of this principle. And in this specific application, it's very important to engage all the actors. So co-regulation, but also participation, for instance, of the citizen. We talk about human rights impact assessment. This is one of my favorite topics in terms of research. And in this impact assessment, it's not something that is done top-down, but it's very important, the level of participation of the citizen. So the engagement of the citizen in the system, not only top-down or bottom-up, but from only specific sector regulation. In this sense, and I want to conclude, something has been already done. Because if you read the guidelines on artificial intelligence data protection adopted by the Council of Europe, if you read, it's not in the list because it's a very specific topic, if you read the ethical charter for judicial decision, artificial intelligence and judicial decision of the Council of Europe, if you read the OECD recommendation on artificial intelligence and the draft recommendation on the human rights impact of algorithmic system of the Council of Europe, inside these recommendation charters and other kind of soft law system, if you want, you find part of these issues addressed, considering the human rights impact, the ethical and ethical impact and social issues, stressing the role of participation, of awareness, and so on. So it's an ongoing process, and in this sense, this image, the idea of a path that brings us towards the mountains in this case, is the image of the state of the art right now. There's a lot of confusion, there are a lot of proposals, and this is the answer to the uncertainty. Probably need time, the dust will set, and we'll have a more clear framework, probably composed by different elements, including law and ethics working together, but without confusing the different role of both. Thanks a lot.